I call David Shearer.
Thank you, Mr Speaker. As David Parker mentioned before, Labor is supporting this bill, and actually supporting it with some enthusiasm, because I think it's a very good bill and well needed at the moment. The evidence bill first came into being in 2006. It was the product of about 10 years of investigation and research by the Law Commission. It's brought in under a Labor government, and I think supported by the National Party at the time. And this bill, sir, is 10 years further down the track and looks to tweak and amend and to improve some of the issues that perhaps weren't as relevant as at the time, or certainly didn't gain the attention of people at the time, but have become issues over the course of those last 10 years and now are being sought to be redressed. And the member who just sat down, sir, went through some of those changes. David Parker looked at the issues around consistent statements, which will be more admissible under this piece of legislation to improve the workings of the court. And I should say, perhaps before getting into the detail of the bill, so the Evidence Act itself is really at the cornerstone of our ability to conduct a fair trial. It really sets out what is admissible, what is not, the behaviour in which lawyers should hold themselves within a court, so that people who are in front of the court get a fair trial, and the witnesses and those people who are the possible victims or the alleged victims are also given a fair go as well. And so, sir, the amendments, the changes to this bill are varied and will make and improve the ability to give the courts the ability to conduct and see that evidence through, so that people are actually able to get a fair trial and make it easier for people giving evidence. So, sir, there was, as I was saying before, the Honourable David Parker talked about the enabling consistent statements to be admissible in the court, makes that easier. It enables privileges for plea discussions to happen and make that more to happen more easily where that is appropriate, and that will enable the ability for the case to go before a court and be able to be heard more easily. But, sir, what of the attention has been focused on is the way in which the victims and the witnesses in crimes of a domestic violence or sexual nature are able to give evidence, and particularly those that affect children. And this is really, unfortunately, sir, long overdue, because New Zealand has one of the worst records when it comes to child abuse and child deaths in the OECD. In fact, we're fifth from the bottom out of 31 OECD countries. It's not a record that we should be in any way proud of. In fact, it's a disgrace. One child is killed every 5 weeks in New Zealand, and 90% of those deaths occur through somebody that they knew, and generally they knew very well. And domestic violence is also, sir, one of the worst in the OECD as well. Again, a pretty terrible record. And we kill on an average every year 13 women, 10 men, and about nine children. Sir, this is these are shocking statistics. But as part of dealing with that is making sure that those who perpetrate these crimes are actually brought through the justice system, and that we are able to make sure that they are punished through our court system. And that means giving the ability of the victims and the witnesses to those crimes the ability to give evidence in a way which doesn't prejudice or affect or further traumatise those people as well. On the same token, the people who were in front of the who are the defendants in these cases, who are in the court, deserve a fair trial like anybody does, like our court system demands that we have. So at the same time, we're not changing dramatically the way in which evidence is able to be considered. It's simply looking at the means and the methods through which that evidence is able to be given by child victims, for example, women who have been perhaps sexually assaulted, and being able to do that in a way where they are not further traumatised by the experience of having to go through that court system and be cross-examined. And sir, I mean, there was a case not so long ago of Mark Leon, who was a businessman, a drug dealer, and who was convicted eventually and sentenced to a number of years in jail for his sexual assaults on girls as young as 14. And one of the fathers of one of those victims said that the changes that are being put forward today would have made a world of difference to his daughter and have frightened children, knowing they didn't have to go into an adversarial courtroom. And he went on to say that his daughter was shown through the court, and although Mark Leon was on the other side of a screen, she was there aware that he who had preyed on her was there and watching everything that she was doing. And it terrified her, the fact that she had to give evidence in front of him. Well, this bill, sir, enables, as the previous speakers just said, that the evidence being given by both the victim and the witnesses can be done through the means, through a video system, through video, rather than having to be there physically present in court. It doesn't mean that they can't be cross-examined, that the defence counsel can't ask questions of them, but some of those questions can be asked through CCTV rather than directly in person, in a court, in front of a bunch of strangers, in front of their possible and alleged attackers and abusers, and therefore, in a sense, re-traumatised as a result of having to do that. So, sir, I think that this piece of legislation, there's other parts to it as well, but I think in many ways that's the most critical part, that in New Zealand, where we have such an deplorable and appalling record of domestic violence, of sexual violence against children, against women, I mean, right across our society, that this bill will give at least some comfort to those who want to go to court and to go to trial in order to be able to give evidence and to make sure that the perpetrators of these crimes are actually taken before the courts and with the possibility that they'll be prosecuted and sent to prison and punished. They will make their job not only easier when they're there, but might encourage them to actually get to court and make sure that those people who have perpetrated these crimes are actually punished. Because I'm sure that a lot of the times now that many crimes that have been committed are not making it into court because of the way in which the court deals or can deal with those victims. And so, sir, if that is the outcome of this piece of legislation, this amendment to the Evidence Act, sir, then I think it will have done a very good job. And once again, like others, I commend not only this bill but also the government for bringing it forward. Thank you.
John O'Neill.